So, good morning, everybody. Usual admin. This has been recorded, and I'll put up some slides. Hopefully, you can see the first one there as well. And a link to the recording and the slides will be sent out later on in the week. So, my name's Kevin Duffy. I'm one of the solicitors and legal advisors in the HR and legal team at Scottish Engineering. And this is the next of the breakfast briefings on the topic of flexible working. And again, just to confirm, can everyone see my slides there as well? Hopefully, yep. Excellent. So first Wednesday of every month, we've got a breakfast briefing, and it's back to my good self to do these. So without further ado, we shall just crack on. Right, so what is flexible working? This is on the agenda, how to deal with the flexible working requests, and if it all goes wrong, what are the claims and what are the penalties that can be raised against a company if they don't deal with it correctly? So, flexible working, it was introduced by the government in April 2003, and it was updated in 2014 as well. And I'll give you an update on what the changes were roughly about that time as well. Now, what flexible working is a method to vary a contract of employment. Now, as you'll be aware, contract of employment is a bilateral legal agreement between the two parties. It cannot unilaterally be changed by one party, or it's very difficult for one party to do so. Invariably, it's the employer who wants to change something against the will of the employee. What you're always looking to do is to get bilateral agreement as opposed to unilateral imposition of the change. So, as you can see from the final bullet point there is no right to flexible working. There's only a right to request flexible working, and that's sometimes lost on employees, and certainly sometimes lost on employee reps as well. Now, what I've put up here is actually a screenshot from the statute itself. Now, I don't usually put up the actual base statutes to these things because they're generally quite dull and they're worded in a very bizarre way. However, this one does exactly as it says on the tin. Okay, and I'll flag here that the law is generally sexist, so whenever it says he, it refers to both he and she. But you can see the actual name of the statute is, it's a statutory right to request contract variation. It's not a statutory right to contract variation, it's a statutory right to request it. And that's very important. And these are all the sort of changes that somebody can ask for. So hours you're required to work, times you're required to work, where you can require to work, and some other aspects of the terms and conditions. Be it, I don't know, whether they can work from home or whether they can work remotely or some other aspect as well. So just to highlight, it's a right to request flexible working, not a right to flexible working. Now, what we have here is various preconditions that were set and were ongoing until the update I mentioned earlier on, 2014. Way back when it started, you had to have a child under 17 or under 18 if it was disabled, or from 2007 onwards, you had to have an adult you were caring for as well. Now, those particular preconditions are now gone, but some of the original preconditions still remain. First off, you have to be a qualifying employee. So you can't be a self-employed person. You can't work for an agency, for example. You have to actually be an employee of the company that you're making the flexible working request to. Also, you have to have 26 weeks length of service as well. If you don't have one of them, that length of service, then you can still request, but it won't be formulated and followed via the flexible working procedure. And also, you can only make one flexible working request within a 12-month period. So if you've made one and then it's accepted or rejected, you can't make another formal flexible working request within a further 12 months of having made that particular request originally. So now that we're past June 2014, there's no need for those caring responsibilities. So in theory, and often in practice, a request can be made for more of a lifestyle purpose. And that very much has been the situation following the pandemic, where there was a large gravitation towards home working, and many people are now particularly reluctant to come back into the office. So what we're seeing is people saying, I don't like my commutes, I like looking after my dog, or whatever. It's easier for me to pick up Amazon parcels. I want to work from home more often. So how to deal with it? Number one, has to be made in writing by the employee, and sent to the employer, and the employer must deal with it in a reasonable manner. Thereafter, there is a 3-month timescale for the employer to deal with it, unless that timescale is extended by mutual agreements, which sometimes happen if it's a more complex case.
Yeah, I wonder if you can help me. I'm phoning up. It's not actually for an appointment.
If I could just possibly stick people on mute. Somebody's on the phone just now.
Description to give me something that on a description would help with for travelling.
Can I put people on mute?
I'm petrified of flying, and I've tried.
Anyway, I'll just crack on.
I go away next Tuesday, and I don't know if they can give me anything. I really don't
right,
know to see anyone.
So agree or refuse. What we have are 8 particular reasons for refusing. These are laid down in the statute as well. And these range from the burden of additional costs through to inability to recruit additional staff, through to planned structural changes. Now, these are just the headlines as such. You need reasoning and some sort of evidence behind these statutory reasons. The company should investigate and give a fully reasoned decision for refusal. So it's not just a bald, we're refusing due to the burden of additional costs, full stop. That's not going to work. That'll just breed resentment with the employee and possibly, depending on the facts of the case, lead to a particular claim being raised against you. So the sort of things that I would be expecting a company to follow when dealing with a flexible working request is ACAS Code of Practice, and the blue writing there is actually a hyperlink to that. So when you get the slides, you can click directly on that and you can read the Code of Practice yourself. Again, what you're looking to do is meet with the employee, give them the right to be accompanied by a work colleague or a trade union rep, discuss the request in detail, ask questions, get quick answers back from them, investigate, and thereafter get back to the employee with that reasoned decision, as I mentioned earlier on, with the right of appeal if you're refusing or partially refusing as well. And again, make sure that you're making reference to at least one of those 8 statutory reasons as well. Now, very often companies will get multiple requests. Certainly that was the case for many of our member companies following the pandemic. So what you have to do is you ultimately can only deal with a flexible working request based on the information in front of you at that time. So it's almost like a case of first come, first serve. Now, that is, again, a bit of a headline. And if you know that there are going to be a number of flexible working requests coming in within a couple of days of each other or a couple of weeks of each other, then you may want to speak to the people to say, look, we're going to have to deal with these all in the round. Because if it's 6 people from the same department of 6 who want to make flexible working requests, then it'd be foolish to deal with them on a one-by-one basis. What you're looking to do is try and deal with them, again, in a reasonable manner. Again, as is often the case in employment law, reasonableness is the touchstone here. Now, trial periods. Generally, a flexible working request is for a permanent change to the person's terms and conditions of employment, but sometimes it can be useful to trial it. In fact, that will often be helpful for an employer, certainly if they're defending a claim for sex discrimination, which we'll touch on later on, is if they are seen to have at least tried it, then that gives more weight to them refusing it, as opposed to them making assumptions during their paper exercise before they refused it. So what you're looking to do is, if it works, make sure you can perhaps suggest a trial period. But what to do is make sure that you make it clear to the employee at the time, saying that this is for a period of 2 months, 3 months, 6 months, or whatever. Now, next bullet point is temporary versus permanent. Generally, flexible working requests are for a permanent change to the employee's terms and conditions. However, that's not always the case. It might be for a finite period of time that the employee wants to change their terms and conditions. For example, if they know that a family member is going in for a pre-planned operation and is going to be under the weather for the next 3 to 6 months or whatever, they may want to move to part-time working or flexible working during that particular period of time. That might be a factor in the employer agreeing with it or not. If the temporary change is put forward and agreed to, then make sure that is confirmed in writing, that this runs between X date and Y date. And thereafter, everybody reverts back to the previous working pattern. So, policies versus ad hoc. Wasn't quite sure what to put in here, but this is I get anecdotally from a number of the member companies. They like to have a policy in place, especially the large ones, so that they have a structure by which they can follow, and the employees know what the structure is going to be when they follow, and the boundaries given on flexible working. For example, people in the logistics department can expect to get flexible working between X and Y boundaries, the people in the admin department between A and B boundaries, and so forth. Whereas other companies, again, invariably smaller ones, deal with flexible working on an ad hoc basis. They get the flexible working request in, investigate it, and then give a reasoned decision based on the information at that particular time. And obviously, there should always be the right of appeal as well against the original decision maker's decision, especially if there has been a refusal or partial refusal. Now, that right of appeal, as is always the case when it comes to things like grievances or disciplinaries or dismissals, that appeal should ideally be heard by a more senior manager who wasn't involved in the original decision. Now, for larger companies, that's easier said than done. And if for a smaller company who's perhaps an SME, owner-managed business, the chief exec is the only senior manager perhaps, then that senior manager perhaps can look at her or his own decision again on the basis of the new information, or can perhaps bring in their company accountant or some other person who is authorised to make a decision on that company's behalf. Again, what to do is, if you're stuck on that at any point to do with flexible working, give us a call here at Scottish Engineering and we can talk you through the practicalities of your own individual situation. Now, as I mentioned earlier on, if it all goes wrong, you might face an ET claim, an employment tribunal claim. Now, agreed employees have a number of different bullets to fire at you if it all goes wrong or they don't like what's happened. There are some standalone claims, and these include failing to deal with the application in a reasonable way, failing to give a decision within the time frame, and rejecting the application for a non-statutory reason. As you see, you've got 8 choices there, so I would hope that that third bullet point would never come out. And if it all goes wrong and you are found to have done something wrong under at least one of those 3 bullet points, you can get an award made against the company of up to 8 weeks' pay. Now, I've been practicing employment law for the thick end of 20 years, and I've never seen one of these standalone claims. Okay, these are very rare. The reason being is that by far the big ticket money claims are under one of these 4 things: unlawful detriment, automatic unfair dismissal, discrimination, and constructive unfair dismissal. Now, what are these? You may have possibly heard these terms before. Now, unlawful detriment is where an employee either makes a flexible working request or has already made a flexible working request and thereafter raises an employment tribunal claim, and because of those facts, the employer visits some bad treatment, some detriment onto the person, almost like revenge. How dare you raise a flexible working request? How dare you raise a claim against us? You're being demoted, okay, or you're being sent to the toilets with a toothbrush to clean them, for example, or you lose some other status. If by reason of them making that flexible working request or raising a claim because of a flexible working request, if you visit detriment onto an employee, then that will be seen as unlawful and you'll be hit with awards at an employment tribunal. Similarly, with automatic unfair dismissal, as I mentioned earlier on, the right to make a flexible working request is a statutory right. And if somebody exercises a statutory right and thereafter is dismissed because of that, or if that's the primary reason for them being dismissed, then that's automatically unfair. Now, as you may know, for ordinary unfair dismissal, you have to have 2 years service. That is not applicable in this circumstance. If somebody is dismissed even on day 1, or whatever, for exercising any statutory right, then that will be found to be automatically unfair dismissal. And just to flag as well, they don't necessarily have to have the statutory right. They only have to have a reasonable belief that they have the statutory right. So say, for example, you've got somebody who has 24 weeks service. They don't have the 26 weeks to make that statutory request, but they reasonably believe that they've got the right to make that statutory request. They make it, and for whatever reason they're sacked for that, heaven forbid, then the fact that they had the reasonable belief that they had the statutory right, even though they don't actually have it, might be sufficient for them to get over the hurdle of claiming automatic unfair dismissal, depending on the facts and circumstances of the case elsewhere. So what you're ultimately wanting to do is, if anybody brings up any sort of statutory right saying that they're not being paid the national minimum wage, or they're not being given their pay correctly, or they're not being given annual leave, all of which are statutory rights. And then after the company visits dismissal on them because of that, then you're perhaps staring down the barrel of an automatic unfair dismissal claim as well. Now, third bullet point here is discrimination. Now, as you may know, discrimination where somebody is treated less favourably because of one of the protected characteristics which are mentioned in the Equality Act. Things like sex, sexual orientation, disability, marital status, things like that. Now, very often, or perhaps historically, it was females, it was women who made flexible working requests more often because they were the primary caregivers in the family unit. So if an employer didn't deal with a flexible working request correctly for a woman applicant, then that person might be able to claim that they were dealt with more unfavourably because they were female, because they were a woman. Now, that would be very blatant if the company was stupid enough to say, you're not getting this flexible working request because you're a woman. That would be direct sex discrimination, of which there's no justification. However, if the woman applicant can say that men generally are dealt with better, or women are dealt with less favourably statistically, then it might be seen as indirect sex discrimination. Now, there is a justification to indirect discrimination under any of the protected characteristics, but it's certainly not an area that you want to get into. What you always want to do is deal with a flexible working request as reasonably as possible and not bring any of the protected characteristics into play. So say, for example, if you were to deny somebody flexible working because, heaven forbid, they were disabled, then again, that would be a very difficult claim to defend for a company as well. What you always want to do is to make sure that any decision you make is, in legal terminology, a proportionate means of achieving a legitimate aim. So all of those actually tie into the 8 statutory reasons as well. Like, the legitimate aim is not to have additional costs, therefore you don't want to have the burden of additional costs, etc. And just make sure you've got a reasoned decision underneath that headline in your refusal letter as well. Again, if you have any particular issues on any flexible working requests, especially the thorny ones, give us a call here at Scottish Engineering and we can talk you through the issues at hand. And the final bullet point there is constructive dismissal, constructive unfair dismissal. Now again, you may have heard that phrase before. Unfair dismissal generally is where the employer says you're sacked. What constructive unfair dismissal is where the employer treats the employee so badly is that the employee can resign and eventually say that they were actually forced out, they were pushed out by the employer's bad behaviour. And it's almost like the employer has ripped up the employment contract in front of the employee and breached the contract in such a fundamental way. Now, what that might be is to deal with a flexible working request in such an unfair or offhand manner that it appears to the employee that the employer no longer cares for the employee, no longer wants to be bound by the terms of the employment contract. And in that case, then the employee might, and I emphasise the word might, be justified in resigning and claiming constructive dismissal. Now, constructive dismissal is actually a relatively high threshold for an employee to reach. It has to be more than just a decision that the person doesn't like. It has to be more than just unreasonable behaviour. It has to be a fundamental breach of the employee's contract, something that no employer, based on the information in front of it, could make. So as I say, it could be taking an exceptionally high-handed approach to the flexible working request, or ignoring it entirely, or not having the meeting, or dealing with it in a very discriminatory and insulting way, for example. All of these things, which all put together, might be enough to allow the employee to resign and claim constructive unfair dismissal. And in that sort of case as well, what you might have is a multiple claim of constructive unfair dismissal, indirect sex discrimination, and then all the standalone claims about not dealing with it in a reasonable manner, etc., etc. So, as I mentioned earlier on, the touchstone for this is dealing with it in a reasonable manner. And as I always say to employers, member companies, when they're dealing with any sort of process or situation with an employee, document document, document. So make sure you send letters, you store the letters received from the employee, you take minutes from the meetings that you have. If there are any emails that go between the parties beforehand, make sure you save them in a separate file, because what you don't want is you to refuse a request, perhaps for absolute justifiable reasons, and for whatever reason the employee doesn't like that reason, the employment tribunal claim, and then 6 or 9 months down the line, you're trying to remember what happened, but you don't have the documentation, the contemporaneous documentation from the time. As I once heard from a barrister who instructed many, many years ago, documents win cases. So in every sort of circumstance, make sure that you have contemporaneous audit trail of documents that were set at the time. Now, I've hopefully not stunned you into submission at this early time in the morning here. Those are my contact details. Does anyone have any questions just now? Happy to speak on any cases you have, or if you want to give me a call to talk in a more private venue, I'm happy to discuss that as well. So folks, over to you. Stunned silence. Okay, right. If that is all we have for this morning, let me just check the chat. Do we have anything in the chat? No, we do not. Right. On that note then, folks, I'll make sure the link to the recording is sent out along with the PowerPoint slides. Tanya, I shall let you go and get your coffee now, folks, and everyone else, off you can get to the rest of your day. Cheers and have a good day.
Thank you.
Take care. Bye-bye.
Thanks.
Thank you. Thank you.
Thanks,
Good night.
Kevin.